ARD or fight your DUI charge in Pennsylvania. How to choose the right move. After a DUI arrest in Pennsylvania, one of the first real decisions you face is this. Do you take ARD, the pretrial diversion program, or do you fight the charge? And the answer is not the same for everyone. In fact, picking the wrong path can cost you your license, your record, your job, or years of elevated insurance, even when the choice felt like the safe one at the time. I'm Sean Quinlan, Pennsylvania DUI attorney based in Camp Hill. This is how to think through that decision correctly, based on your facts, not just the first offer on the table. What ARD actually is and what it isn't. Let's start with ARD because it's widely misunderstood. ARD, Accelerated Rehabilitative Disposition, is Pennsylvania's pretrial diversion program, most commonly available to first-time DUI offenders. In plain English, the prosecution pauses, you complete the program terms, the charge gets dismissed, and you can usually seek expungement afterward. That is a genuinely good outcome, but it's not the same thing as winning, and it's not the same as proving the case was weak. ARD is an agreement. You're not beating the DUI. You're accepting a structured resolution that avoids a conviction and keeps the damage more contained, in exchange for fees, supervision, classes, treatment if required, and staying out of trouble for the duration of the program. For a lot of first-time offenders, with a strong evidence against them, that's exactly the right move. For others, it's leaving a better outcome on the table. Here's the thing that most people don't hear clearly enough. ARD can still count as a prior DUI disposition in some future situations under Pennsylvania law, which means if you're ever charged again, that ARD may not protect you the way you think it does. What fighting the charge actually means. Fighting a DUI charge doesn't mean walking into court and saying the arrest was unfair. It means testing the government's proof, piece by piece. Was there a lawful reason to stop your vehicle in the first place? If not, everything that followed may be vulnerable. Were field sobriety tests conducted in conditions that made a fair evaluation impossible? Bad lighting, sloped pavement, bad weather, wrong footwear? Was the blood draw delayed, mishandled, interpreted without critical context? Did a medical condition or prescription medication make you appear impaired when you were not? These aren't fishing expeditions. They're the places where DUI cases actually have weaknesses, and those weaknesses matter. A successful defense can result in a dismissal, an acquittal, or a reduction to a lesser offense. Any of those outcomes is cleaner than ARD from a record standpoint. Even when a full dismissal isn't realistic, a defense can create leverage. If the evidence has problems, a prosecutor may become more willing to negotiate a reduction or a different resolution. Weaknesses in their case often translate directly to better options for you. The decision framework. Evidence first. Here's the core framework for making this decision. Start with the strength of the evidence against you. That's a big variable. If the prosecution has a clean case, valid traffic stop, solid officer observations, properly administered field sobriety tests, reliable chemical testing, clean chain of custody, no meaningful holes, ARD often makes more sense if you qualify. You're not walking away from a likely win because there may not be one to get. If the case has real problems, a questionable stop, sloppy field sobriety testing, a blood draw with procedural issues, missing dash cam or body cam footage, or a refusal that's being disputed, or a medical issue that was never properly addressed, fighting is not stubborn, it's smart. A few specific things that can make a case weaker than it looks on paper. Blood alcohol can rise after driving, which matters when testing happens sometime after the stop. Field sobriety tests are affected by age, footwear, nerves, injuries, and roadside conditions. Prescription medications and medical conditions can blur impairment assessment in DUI drug cases. And an officer's report can sound stronger than the video, especially when the video is missing. When the evidence is shaky, ARD is paying to resolve a problem the prosecution might not be able to prove. How each path affects your record. This is where people often don't think far enough ahead. ARD protects your record in a specific way. Complete the program, get the charge dismissed, then petition for expungement. That process works, but it's a path around the case, not through it. A successful defense, a dismissal, an acquittal, a reduction to a non-DUI offense, can protect your record even more cleanly. You're not taking a structured resolution that still shows up as a prior disposition in some future legal contexts. You're attacking the case and potentially removing it from the picture more completely. The trade-off is real, though. A failed defense ends with a conviction. ARD is more predictable. Fighting has upside, sometimes significant upside, but it carries risk that ARD doesn't. That's why the strength of the evidence isn't just a starting point. It's the whole basis for risk calculation. License consequences, where the fight often pays off most. For a lot of people in central Pennsylvania, the license is the real issue. Courts matter, but getting to work on Monday morning matters too. Here's where fighting the DUI charge can pay off in ways that go well beyond the courtroom. Pennsylvania's license consequences vary by tier. A first offense general impairment case may not trigger a suspension. Higher BAC tiers usually do, 12 months for many first offense high rate and highest rate cases. A refusal can create a separate PennDOT suspension even before the criminal case is resolved. And ARD itself can still carry license consequences depending on your tier. Now here's the key. If a successful defense challenges the BAC evidence, changes the grading of the charge, or defeats the refusal issue, the license outcome can improve significantly. That's a practical, real-world result that a straight ARD resolution might not achieve. If you drive for a living, that difference can pay the rent. CDL holders face especially serious consequences. Commercial driving privileges can be threatened even by a first offense, and the disqualification rules leave far less flexibility. For CDL holders, the license consequences often outweigh every other consideration in the fight versus ARD analysis. Professional license and career concerns. ARD avoids a conviction, and for many jobs that's enough. The charge gets dismissed, expungement follows, and the record impact is contained. But sometimes enough isn't enough. If your employer, licensing board, security clearance, or background screening process looks closely at arrests, pending charges, license suspensions, or alcohol-related incidents, a full defense may protect your livelihood better than ARD does. Nurses, teachers, healthcare workers, contractors, military members, these aren't hypothetical examples. These are people whose boards may ask about ARD completions, pending DUI cases, or license-related actions even when there is no conviction. The right question is not just, can I get ARD? It's, what will show up, and when, and to whom? For some people, the answer to this question makes fighting the charge not just the better legal move, but the only career-safe one. Financial picture, long-term versus short-term. ARD often looks cheaper at first because it feels contained, but the full cost includes program fees, probation costs, alcohol highway traffic safety school, treatment requirements, ignition interlock expenses if applicable, and insurance increases that can run for years afterward. Fighting a DUI charge usually means more legal work up front. Motions, hearings, expert review, possibly trial. That costs more in the short run. No point pretending otherwise. But the long-term math can favor a stronger defense. If fighting avoids a conviction, protects a professional license, saves a CDL, or reduces insurance fallout for 3 to 5 years, the higher front-end cost can end up being the cheaper path overall. A quick resolution is not always the least expensive one. It's more like grabbing the first estimate for a roof repair without checking whether the actual problem is bigger than it looks from the outside. When ARD makes more sense. Let me be direct about when ARD is usually the right call. ARD makes more sense when you're a genuine first-time offender. You qualify cleanly, under county screening rules, and the evidence against you is strong. If the stop is valid, the testing was properly administered, the chain of custody is clean, and there's no meaningful defense issue to press, ARD gives you a faster, more predictable landing. It also makes more sense when your main goal is avoiding a conviction and getting to expungement as efficiently as possible, or when the risks of fighting outweigh the realistic upside, given the strength of the prosecution's case. In those situations, ARD is not settling. It's making a smart, practical decision based on the actual facts in front of you. When fighting makes more sense. And here's when fighting is the better call. When the traffic stop looks questionable, when the testing has procedural problems, when a refusal issue is disputed, when the charge is graded in a way that creates major license exposure, when ARD won't solve the professional or career problems you're facing, when you're not eligible for ARD and need a defense strategy regardless, or when the evidence simply isn't as strong as the arrest paperwork makes it look. which is more common than most people realize at the time of arrest. Taking ARD too quickly in those situations is a bit like paying a parking ticket without checking whether the meter was even working. If the stakes are high and the evidence cracks, pushing back is not stubbornness, it's the right move. ARD or fight? There's no universal right answer. The right answer depends on your evidence, your tier, your license exposure, your career, and what the long-term picture actually looks like if you take the fast path versus the better one. Here's what to do right now. Get every report, every notice, and every date in one place. Then have the case reviewed before you pick your lane. This decision is too important to make based on the first offer that lands on the table. If you've been charged with a DUI in Pennsylvania and want to understand which path actually makes more sense for your specific case, reach out. Free consultation, no pressure. Link is in the description. Subscribe for more straight talk on Pennsylvania DUI law. See you in the next video.